Recognize been showing love, then got my grind right. Ain't never since day one the love been on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be.
Definition of bestie, definition of friendship, definition of rider, definition relentless. She's a strong woman, she's a sweet lady, she's a great mother, let your pain get aching. Yeah, I made that girl on YouTube, she never dims my light or put me in her dark mood. And I thank you, you appreciate it. You're my favorite girl on YouTube, and I can't fake it. You still got faith in me, make me feel like big. DJ Khaled voice, pretty hot damn. Who still got faith in me, make me feel like big. DJ Khaled voice, pretty hot damn. Met a little shawty on this show called BDP, you know what I'm talking about? Shit, we been cool ever since, my nigga, you know what I'm talking about?
Put your eyes on me, like the spotlight. Recognize been showing love, then got my grind right. Ain't never since day one the love been on side. And since you got my back, I got your back for life. Yeah, pretty honesty. Know just what it is, I got it on me. And you hold me down, you like my homie. Just know I got you down, just what it gon' be.
If you guys are into herbal refreshments, I got the person for you. DD packs are where it's at. Contact DD at DD, and it's spelled DEEDEEMC 7777 at gmail.com, and use Pretty Iced Tea for your 10% off, and all first-time customers will get free shipping. Again, DD Packs, it's where it's at. Me? Am I staticky?
You are not static.
Thank you, Jesus. What's up, Jordan? West Side Rider, don't you start with them damn tomatoes. I'm not in for a tomato facial this early.
So, here's what it is. The video is behind a paywall. When I click on it, it says this video requires payment to watch.
Okay, then let me get the other one. Them motherfuckers, they want to play with me today. How are you going to put a trial behind a paywall when it's free to watch it for everybody?
The same way they be putting people's videos that are free to watch on YouTube behind Patreon.
Oh, Lord have mercy. Okay. Oh, okay. Do Court TV then.
Okay, Court TV. Let's go.
So fuck you, Law and Crime. We'll steal somebody else's video. I need to know find out how I can sign up into Zoom. That's what I really need to do.
Oh, I don't know. No, wait a minute. Okay, I believe it's on. It just I don't think they're saying anything right now because the video is just quiet. But I'm going to share the screen anyway.
Okay. They said 8:30, but you know, courts, they're never on time.
Okay, here we go.
Pull you up. Yeah, they're probably still waiting for them to start.
Okay.
Do you know who this is? Just my five.
Uh-uh.
That we're gonna. Oh, so this dumb fool, he married abroad. She already killed her. She killed her, and I could say that because, well, he's allegedly. She allegedly had her ex-husband killed.
Oh.
They think, yes, they think that her brother thought him. Well, he said it was self-defense, but they're trying to get her for conspiracy charges on that one too. But her
Uh-huh.
twin went missing in 2018. It was 2018.
Good.
And she married this dude, went on a whole hiatus, went all the way to Hawaii. They were brought back. She went to jail, but he didn't. And then they were looking into his ex-wife's murder because when they got together, she mysteriously died as well.
Wait, hold on.
And then,
Hold on. Somebody's calling.
okay. Ooh, looks like we should.
Child, ain't nobody calling me. That's my 10 o'clock alarm. Anyway, look.
Good morning, everyone. We're on the record now on
Here they
Fremont
go.
County, KCR 22-21-1623, State of Idaho versus Chad Guy Daybell. Let me confirm with our tech people and clerks here, is the broadcast on?
Yeah.
Thank you. The court will note that as we get started, there is a courtroom conduct order in effect that you've all been advised. Please pay attention to the terms of that order, including making sure you don't have any devices that would go off and interrupt proceedings. No recording within this courtroom or photography of any type. The court is providing public access through the open proceedings as well as the live stream that's being conducted. With the court's live stream, we have, I think, good technology in place to accomplish that. If something comes up that interrupts the live broadcast of this trial, and this will be throughout the trial, we'll give an opportunity to try to get that started again. However, if there's going to be any kind of significant delay in the live stream broadcast, the court will be continuing on with the proceedings. So there may be gaps in that, but I think our technology is in place that hopefully that won't occur. But just so those listening in understand, if it does come up, we likely will not pause the trial longer than necessary to make that accommodation. At this time, I'll note also for the benefit of counsel, we do have all 18 jurors, our 12 jurors with 6 alternates have arrived this morning, and everyone has submitted their juror affirmation sheet regarding following the court's admonishment while they've been gone. No issues to bring up on the affirmations of the jurors. So with that in mind, then let me go to the state, knowing the state is here present. Is the state ready to proceed this morning?
Yes, Your Honor. Thank you.
Thank you. Is the defense ready to proceed?
Yes, Your Honor, thank you.
Okay, thanks, counsel. All right, before we bring the jurors in, which we'll do very shortly here, I also, as we are getting started and before the jurors are sworn and we take evidence, is there, I believe we've already had a motion to exclude witnesses. Let me just clarify on the record, is there going to be a motion to exclude witnesses through evidence portion of the trial made by the defense?
Yes, Your Honor. So,
Very well. The court will reaffirm then there has been a motion to exclude witnesses. So as the state begins with its case in chief, keep that in mind that they are not permitted to observe the trial proceedings, including the live stream. The only exception would be for a witness if they statutorily qualify as a victim, then they are permitted to observe the proceedings. So each witness is going to be questioned whether or not they've observed any trial proceedings, and I would instruct the state, and then following the defense. They have witnesses to make sure that the exclusionary rule is followed. Does the state have any questions on that matter?
Your Honor, the state would just clarify and just make counsel and the court aware. It's the state's understanding that through the Constitution and statutorily, victims have a right to remain in the courtroom throughout the proceedings, regardless of whether or not they are victims. And we have discussed that with defense counsel and made the court aware of who we think there may be a crossover with, meaning individuals that may be present and also witnesses. But statutorily, they would have the right to be here. So including any of the defendant's children, as well as, since they were Tammy's children, as well as siblings, sometimes grandparents. The court made a ruling last year in the Lori Vallow case. I think if we're following a similar guideline, those are the individuals that we would just note for the record may be present at times, but should have the right to be present throughout the proceedings. In addition, I would just note for the record that we do have our case agent who will be present for the duration of the proceedings, and that's Chief Deputy Vince Kaikamani.
Okay, and the state's permitted their case agent as it relates to victims. The court agrees they are permitted to see the proceedings, including if they are a witness. We would take up on a witness by witness basis whether or not they fall within the statutory qualifications permitting that. And I know the state's aware of the issue. We'll make rulings tested as to whether or not they would qualify and later called to testify. Mr. Pryor from the defense, any further comment or questions on the exclusionary ruling?
Nothing further, Your Honor.
Okay, thank you. All right, this time then we will have the jurors brought in.
Yes, sir.
Let's go. Let's get the show on the road. Let's go.
All rise.
Oh, the jury is present and accounted for.
All right, thank you, Mr. Bale. Please be seated.
Okay, I just wanted to say, I don't know what kind of courtroom this is, but usually witnesses aren't allowed to be, witnesses aren't allowed to be in the
Ladies and
courtroom.
gentlemen of the jury, we're on the record on Fremont County KCR 22-21-1623, State of Idaho versus Chad Daybell. We're ready to proceed with opening arguments and initial instructions this morning to you as jurors. The court notes that the prosecution is present as well as the defendant and the defense attorney representing him as well. We have qualified this panel of 18 jurors consisting of our 12 jurors with 6 alternates, and they are now seated for trial. Let me start with the state and ask, will the state agree that the jury has now been properly seated and ready to be sworn?
Yes, Your Honor, thank you.
Will the defense agree as well?
Yes, Your Honor.
Thank you.
I just want to say that is
All right, ladies and gentlemen of the jury, thank you for returning this morning. You're now seated as jurors in the case before us. As previously been told, I'm Stephen W. Boyce, the District Judge of Fremont County in charge of this courtroom trial. I'll briefly reintroduce you to some of our court personnel assisting here today. Shannon Holstein, seated to my right, is the clerk who is keeping minutes of the trial proceedings, will be marking trial exhibits and administering oaths to you as jurors and to the witnesses. We do have our courtroom bailiffs as well who assist with keeping order in the courtroom and helping the jury move about where they're supposed to throughout the day, and in enforcing any conduct orders we have in effect here for the trial. Our Court reporter today in land is taking a stenographic record of everything said during the trial proceedings, and my staff attorney, Courtney Stallings, is seated to the far right, who assists me with legal research and administrative matters.
I hate that they have them so
throughout
far away from the
doomsday
camera.
trial. Each one of you has been qualified, examined, and selected to serve as a juror of this court. The clerk will now have a roll call of our seated jurors. Please, Madam Clerk, if you would conduct the roll call. As to each juror, once your juror number is announced, please just indicate present or here verbally so we acknowledge that on the record, Madam Clerk.
Juror 27, present. Juror 219,
Here.
juror 505,
Here.
juror 631.
Here.
Juror 653.
Here.
Juror 686.
Present.
Here,
752.
Present.
Juror 1680, present. Juror 823.
Here.
Juror 1358.
Here.
Juror 1365.
Not here.
Juror 716. Here. Juror 750.
here,
Juror 997.
Here.
Juror 1078.
Present.
Juror 1577. Here. Juror 1271. Juror 1382. Present.
Thank you, Madam Clerk. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. The state is here represented in this trial by Lindsay Blake, Fremont County prosecutor. Ms. Blake, could you please stand briefly? Also, Rob Wood is the Madison County prosecutor. Ingrid Beatty is a special assistant prosecutor. And Rocky Wixom is a Fremont County deputy prosecutor. The defendant in this case, Mr. Daybell, is represented by his attorney, John Pryor. Thank you, counsel. In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment. And please remember, again, it's a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer would state the law to be. During this course of the trial, including opening statements, you're instructed that you are not to discuss this case among yourselves or with anyone else, including using the internet or social media or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. And do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. The court's given you that instruction now multiple times, and I will continue to give you that instruction. And again, that's not because I don't think you're not paying attention. It's just important enough. We'll keep reiterating that. And I will note we received the juror affirmations today from each of the jurors indicating they have followed that instruction. So thank you for that. At this time then, the next matter we'll take up is to have this jury placed under oath for trial. At this time then, Clerk, if you're ready to administer the oath, I'll have the jurors stand and be placed under oath. When you stand, then please raise your right hands.
You solemnly swear or affirm that you will try the cause now on trial and a true verdict rendered here in accordance with the law and the evidence, so help you God.
All right, thank you. Please be seated. All right, the jurors have already been advised of some of our trial procedures in this case, and I'll just give you some additional general information here. Our normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified for certain reasons. Sometimes we have matters to be argued outside of your presence. Sometimes during the recesses, they may seem to go long because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while you're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure you are as comfortable as you can be and able to be alert and attentive throughout the presentation of evidence in the case. These seats that you have been assigned to at this time will be your specific seat throughout the trial. Please return to that same assigned seat each day or after each break so that we are able to determine who's here and if someone's not for some reason, who's not here. If there are interruptions at times during the trial, I know that can be frustrating, but we'll work our best to keep those to a minimum, move the trial as long as efficiently as possible, but at times it just takes time to hear motions that are necessary outside of your presence. And then the courtroom and your location for deliberations, as well as during the trial where you'll be held. We've provided, of course, access to restrooms and other needs you may have. I'll address your compensation here. State law allows you for $10 a day for your jury service. However, after 5 days, that bumps up to $40 a day. So this trial is expected to go some time. You'll likely get into that increased range of compensation, and that's pursuant to Idaho Code 2215. You're also entitled, I believe, to a mileage reimbursement for travel each day, and that can further be explained to you if you have any questions. Also, you may notice from time to time, or a lot of the time, I'm looking at monitors here during the trial. I do have case information here and availability to access and research things from the bench. And so if you notice me looking at those monitors, it's generally to assist me in trial issues that come up. At this time, then the court will provide the jury with some additional jury instructions. As I read through these, it's somewhat lengthy, and I will notify you that you don't have to necessarily memorize everything I'm saying. When the trial is concluded and you deliberate, you will have printed copies of these instructions to return to for reference. And if you'll give me just a moment here, I have a brief inquiry to make with my staff attorney. All right, thank you. Now that you've been sworn as jurors to try this case, I'll go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence but is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I will give you additional instructions on the law. After you have heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing arguments. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. The defendant is charged by the state of Idaho with a violation of law. The charges against the defendant are contained in the amended indictment. The amended indictment is simply a description of the charges. It is not evidence. Jury instruction number 3. The defendant, Tammy Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Daybell and or Alex Cox and or other co-conspirators. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant, Tammy Daybell, in this case, and should not speculate as to any other case or legal proceedings involving any alleged co-conspirators. You must remember that the defendant, Tammy Daybell, has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, the proof need not show that it was committed on that precise date. Instruction number 5. Under our law and system of justice, the defendant is presumed to be innocent. Presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Jury instruction number 6. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any.
He's not going to testify.
The defendant may not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Jury instruction number 7. If during the trial I may say or do anything which suggests to you that I am inclined to favor the claims or positions of any party, you will not permit yourself to be influenced by any such suggestion. I will not express nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I will instruct you to disregard it. Jury instruction number 8. Your duties are to determine the facts, to apply the law set forth in my instructions to those facts, and in this way to decide the case. In doing so, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked a witness, or to a witness's answer, or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question, or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law which should apply to this case. Sometimes that will occur over on the corner there, and we do have a device here that whites out the noise so you can't hear us speaking there. At other times, I'll excuse you from the courtroom so that you can be comfortable while we work out any problems with evidence. You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all of the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings and making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such an opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. Jury instruction number 9, at the conclusion of the trial, you will decide as to each charge whether the state has proved the defendant guilty beyond a reasonable doubt. The subject of penalty or punishment is not to be discussed or considered by you in making these decisions. That is a matter which must not in any way affect your verdict. Jury instruction number 10. The state is seeking the death penalty in this case. If the defendant is convicted of murder in the first degree, there will then be a separate sentencing phase of the trial. At that sentencing phase, additional evidence may be presented and the jury will be given additional instructions. At the conclusion of that hearing, the jury will then decide if the defendant will be sentenced to death. If the jury decides that the defendant will not be sentenced to death, either the defendant will be sentenced to a term of life imprisonment without the possibility of parole, or the judge will sentence the defendant to a term of life imprisonment during which the defendant could not be paroled for at least 10 years and possibly for life. Jury instruction number 11. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until after you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, you'll leave your notes here with the bailiffs. If you do not take notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign one person the duty of taking notes for all of you. Jury instruction number 12. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. First, do not talk about the case among yourselves or with anyone else during the course of the trial. You should keep an open mind throughout the trial and not form or express an opinion about the case. You should only reach your decision after you have heard all the evidence, after you've heard my final instructions, and after the final arguments. You may discuss this case with the other members of the jury only after it is submitted to you for your decision. All such discussions should take place in the jury room. Second, do not let any person talk about the case in your presence. If anyone does talk about it to you, tell them you're a juror of the case. If they won't stop talking, then report that to the bailiff or courtroom staff as soon as you're able to do that. You should not tell your fellow jurors about what has happened. Third, during this trial, do not talk with any of the parties, their lawyers, or any witnesses. By this, I mean not only do not talk about the case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from you as jurors. Fourth, during this trial, do not make any investigation of this case or inquiry outside of the courtroom on your own. Do not go to any place mentioned in the testimony without an order of the court to do so. You must not consult any books, records, internet, or any other source of information unless I specifically authorize you to do so. Fifth, do not read about the case in the newspapers. Do not listen to radio or television broadcasts about the trial. You must base your verdict solely on what is presented in court and not upon any newspaper, radio, television, or other media account of what may have happened. Each day you will be required, as I mentioned, to sign an affirmation that you will follow this admonition of the court. That concludes the court's first instructions then, and as I mentioned, you will be provided copies of those when you deliberate for further reference. Next, at this time then, I am going to have the clerk read the amended and redacted indictment to you. Madam Clerk, if you're ready to read the amended indictment, please do that at this time.
In the District Court of the 7th Judicial District of the State of Idaho and for the County of Fremont. State of Idaho plaintiff versus Tammy Daybell defendant, case number CR 22211623, amended indictment. Tammy Daybell is accused by the grand jury of Fremont County of this indictment as follows. Count 1, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Tammy Daybell and/or Lori Daybell and/or Alex Cox, deceased, and/or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. Count 2, first-degree murder. The defendant, Tammy Daybell, on or between the 8th and 9th day of September 2019, in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal transactions in Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, either kill Tylee Ryan and or assist in the killing of Tylee Ryan and or did encourage the killing of Tylee Ryan and or did command another to kill Tylee Ryan in violation of Idaho. Count 3, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Guy Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018 and continuing until January 15, 2020, excuse me, in the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, that willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Joshua Jackson Vallow, hereinafter J.J. Vallow, and to commit grand theft by deception. Count 4, first-degree murder. The defendant, Chad Guy Daybell, on or between the 8th and 9th day of September 2018, in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal transactions between Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow in violation of Idaho code. Count 5, conspiracy to commit first-degree murder. The defendants, Chad Guy Daybell and or Lori Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the County of Fremont, State of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction in common scheme or plan in Fremont and Madison counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tammy Daybell, and did combine or conspire to commit murder, and one or more of such persons did enact to effect the object, combination, or conspiracy. Count 6, first-degree murder. The defendant, Chad Guy Daybell, on October 18 to 19, 2019, in the County of Fremont, State of Idaho, was concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, did either kill Tammy Daybell and or assist in the killing of Tammy Daybell, and or did encourage the killing of Tammy Daybell,